everybody. Introduction to Legal Research by Tactical Sovereignty. And we're just going to cover some basic details this evening. People don't know what to do really when something gets going with a court case or whatever, whether they have an attorney or if they prefer to do it pro se. So Jeremy and I are just going to be covering a little bit of that information tonight, just so that people don't feel quite so green when something like this comes along. How you doing tonight, Jeremy?
Very good. Thanks for having me. What do you want to go over?
Well, let's go over just like a basic for discovery, getting discovery. I've had people say, "Oh, should I go down to the courthouse and do it?" And myself with everything, I kind of prefer to keep a paper trail on everything I've been doing. Kind of helps keep stuff straight, and it's a lot faster and easier as well.
Well, there's a situation when you're usually doing discovery. Usually you do it between attorneys. Like if you have a prosecutor, you send them a direct notice and asking them for discovery. And then whenever they don't give you something, then you compel them. But you usually try to keep a normal procedure of business. If it's possible, try to be civil and try to get the discovery from them. Usually, sometimes when you're asking them, they might make you pay for it, but I don't know. You can usually get it without having to pay for it. But the main thing is you have to get it from your opposing party. Usually, whenever you're looking for something that they're trying to say that they have, and this applies to civil and criminal. But this is basically what I'm getting from the rules. I mean, I'm not making stuff up. I'm just showing you what you're saying. If you go by the rules of the court, they'll usually give you an angle on how to get discovery, and usually that's always secondary based on you trying to get discovery from them without having to use the court. Usually you only use the court when you're trying to compel them, is the way they do it in several different states. I don't know how it applies over there, but that's usually what it is. You talk to them, and you try to confer with counsel.
Yeah, normally it's a situation of compelling. No, I can't remember what it's called now. Deuces. Gosh, I can't think of it now. But I received one of those one time, basically where they wanted documents from you. You know what I mean? And so they use the court to compel you to do that. And normally it starts out with a motion hearing to compel. So.
No, I get that. Well, no, there's quite a few different discovery requests, man. I mean, it just depends on what kind of case you're in. I mean, you've got things like interrogatories, and you've also got, requests for admissions, and you've got stuff like that. There's quite a few different. There's petition for a more definite statement too. You've got all these type of things when you're trying to attack arguments in the civil realm. There's also like sister laws that kind of go over to criminal, but then there's family too. But everyone's got their own rules, so you have to kind of read the rules to see how everything applies. Don't ever think you're going to go in there and wing anything. I mean, that's for sure. But the main aspect is to try to understand what you're trying to do, write out your plan of action, and then see what your angle is. Try to give them a discovery request, basically requesting what's material and relevant. Always try to make sure that it's an argument that's simple, but you don't want to give them what you're looking for. You only want to explain to the court why it's materially relevant in order to compel them. Usually, when you're talking to counsel, you ask them the reason you need this because of this, and if they don't give it to you, then you can compel them. You always kind of got to give them notice first.
Right. Well, and one of the things I brought up with you earlier, and this is fresh on our mind because Jeremy and I were talking about this a little bit ago. I've noticed that Well, one of the main concerns, it seems like in this group, is a lot of family law situations and people wanting to get either children back or grandchildren back. I'm not that familiar with when it comes to a grandchild situation. Um, I think you're kind of like maybe one step removed out of the situation, so I don't know how
There's a
quick.
local, there's an angle on local parentis, stuff like that. There's all kinds of different angles. You've got things that you can do for adoption. You've got things that you can do for all kinds of things. It just depends on what angle you're looking at. There's books online, like you can grab a book that studies family law and kind of breaks it all down for you. I mean, you can get an I believe on Kindle and stuff, kind of like what you did with the Gilbert's law summaries. And you want to check that out. Make sure to share that information. Yeah, if you wanted to share the same information in regards to family law, they do have that stuff, and they do expand on it. It's more or less a complex little area because it's so personal, I would say. So some of the words are hidden to mean different things than what you would think they would mean, kind of just because of privacy issues, I believe.
Yeah, especially with dealing with families, you're generally dealing with minors in those situations. So yeah, you're going to run into a lot more privacy issues regarding those things. And to me, I don't know. I've witnessed some things that just kind of really shocks me, even from the standpoint of how defense counsel should be acting. You know what I mean? And people have to realize that you can go back to what is it, Section 4 of Corpus Juris Secundum, Book 7, and it tells you where the loyalty lies at when it comes to an attorney. And generally, unfortunately, it is the client comes last. It's the courts come first. The attorney has other allegiances that they've already made. Um,
Well, it's not, you never do it to make a fool of the court. That's kind of the rule of thumb is really what it is. But the aspect of it is sometimes it's just the standard of decorum that kind of has to be presented to keep professionality. So you don't want to disrespect the king. You know what I mean?
right.
So you kind of got to get the aspect of don't disrespect the dude that's ruling over the situation. Um, just meets a lot of levels of common sense, really.
Yeah, you want the person that's making the decision to be on your side as much as possible. You want them to like you as much as possible, for starters. So,
In
and
anything you do, you're not trying to piss the guy off at the store right before you get your item that you're buying. You know what I mean? I mean all that kind of stuff. It's just common respect.
yeah, well, and it's common sense. I mean, you wouldn't want to piss off your surgeon just before he puts the gas mask on you to put you into surgery. So,
Yeah, right.
or
I mean, there's just all kinds of things.
uh, you don't raise hell with your waiter or waitress, before you received your food.
I might spit in it or something, right?
Yeah,
Well, you don't might see something that you don't want to see and create a scenario you don't want.
exactly. So, but one of the things we're covering and what we are just talking about was, getting discovery. It's people have to realize that in the court situation, like Jordan Maxwell has said, it's a game. It's done on a court. Well, in any kind of game, everything is supposed to be an even playing field. So you have a right to discovery. Both sides have a right to know what each other are doing. They're not going to divulge their full game plan or anything, but you need to know what evidence they do or do not have against you, and because otherwise you can't go in there blindly. You go in there blindly, and you're going to get the shaft every single time.
Oh, absolutely. Well, I mean, if anything you don't prepare for, you're going to lose.
Yep.
Kind of
Yeah,
like the rule of
back to
thumb
that.
there.
Back to that game idea again. Game theory. You know, and It's kind of a
Well,
chess match.
I don't really look at it as a, it's a, it is a chess match. It's a chess match for words, but that really doesn't explain it. It's a form of public debate, in public debate with motions moving the court. It's a parliamentary procedure that's implemented that a lot of people are just not familiar with. So being able to move the court is to be able to act like they do, and moving the court is to make a request. So you've got to understand the complexity of when you get in there of what the things are, what you're trying to do, what you're trying to understand, what is going on here. Usually you're getting in there, and any court you get into, you're going to have a judge. The judge is going to be the one that signs the orders. You're going to have an opposing counsel, and the opposing counsel is going to try to give you a position to defend their stance. Usually they'll come up with a theory or whatever they've got, and based on the evidence. Now, you as a defendant have the right to not screw yourself in the very beginning of this area. So you have to really pay attention to what's going on. So you're getting yourself into an adversarial proceeding where you can trap yourself by the things that you say, and everything that you say you pretty much have to own, unless you have made a misstatement and you were wrong. You know what I mean? But you don't ever want to lie. That's why it's very good to stand in truth. Always stand in truth is basically your best weapon. But really, it's like a fight, man. It's really not just like a chess match. It's more or less war without bloodshed. It's a little bit more complex than just a chess match. This is serious, intense, moment by moment intensity. You're not going to get scared by your next chess move. They can scare the hell out of you just by doing this, doing that. So it's a little bit more real where you are the character, but it's not king against king. It's more or less king against I guess it's a form of like slavery in a way. I'm not exactly sure, but it seems like in the criminal aspect, they act like all your rights are gone. And when you're in the law, your rights are gone. You get to a point of like being stripped. It's a very, very scary situation. There was also times where you're in civil situations where you could say things would be held in contempt. So you've got to really be careful. And moment by moment in a boxing match, you could get knocked out real quick by just one move. And it pretty much goes the same way. So, and it goes the same way with any battle. But chess, you have to do a whole bunch of moves just to take out the king. It's more or less any move can take you out. So it's the fight from the very beginning, and it's open mouth, whatever the heck you can find. Take your opportunity as you can, and that's pretty much. If you don't take your opportunities when you have them, you might as well just give up. It's like getting a boxing match and say, I can uppercut this guy, or I can take his left hook and get knocked out. Which one do I want? Well, I think we're gonna have to go for the uppercut. And if you're gonna go and mean, you're gonna have to take it and finish it off. You can't just be like go halfway and be like, nope, I'm not gonna finish, because they will mess you up when you do that stuff. So anything that you do, you got to kind of own. But yeah, I wanted to give it a little bit more expands on that because of experience, being in there and seeing what it really is like. It's a little bit more horrifying than just a chess game. Is all I'm saying.
Yeah, the results are going to be a lot more lasting or permanent than it would a simple game of chess or checkers. So
Mm-hmm.
it's life altering situations.
Yeah, so you want to make sure that if you have no experience debating people or arguing people on simple things, do not try to go in a public forum and try to argue against people. You're just not set up for that. But if you do, and maybe you argue with your brother, or your sister, or your mom, or your friend, or cousin, whatever it is. Granted, Were you able to argue in front of other people in the family or other friends and get them to agree with you? If you've got that type of energy, you've got a shot. The thing is you just have to be able to understand your argument. You want to be able
Yeah,
to close, and if you can't close your argument and come to a logical conclusion, no one's going to follow you.
and one of the biggest things I see as well in talking to people that are dealing with different things like this is that, and I notice this even in just regular life. People think they can come to you and tell you something, and they're just giving you a small piece of the story. Granted, they know the whole story, but it
Yeah,
doesn't dawn on them that you don't know the whole complete story, you know? So you really have to lay out the full circumstances for the other party or for whoever's making the decision. That way that they fully comprehend everything that's going on there.
yeah. You don't ever want to prejudge something,
Right.
especially when you're getting into cases. You want to read those things out pretty thoroughly. I would be like one of the really most effective tools I've ever seen was just analyzing how the facts in the very beginning to see if their facts properly invoke the elements for the charges. That's one of those things that really changes the case. And if you don't really know how to do that, it's really easy, really. All you got to do is look at the damn statute, see what it says, and see what your facts are, and see if it clearly supports what it's being said. And if it doesn't, then you've got angles and you've got issues with the case, but you've got angles in defense that you can act on, and then you can use that as your offense. The more
Well, I think
holes that you find in a case, you always got to remember, just because you got one little kind of thing doesn't mean that it's that good. Always kind of save your cards a little bit. And you remember, I was talking to somebody the other day. It was about, how like you have one piece of an ingredient. You don't be like, this is biscuits because you got flour. You don't say, this is biscuits because I got salt. This is biscuits because I got pepper. You put all the ingredients together. Now this is what it is. And then now I got the ingredients for biscuits, and now we're going to make some biscuits. Now that aspect is a little bit different. So you're going to collect all these pieces through your case. And the reason why you want to collect quite a few of them is so when you hit them, they're kind of overwhelmed by your fact pattern and your evidence that supports what you're saying. You don't ever want to go and shoot early, because if you shoot early, you could give up your whole. You can give up your whole win. It's kind of it's a fatal shot to give up your cards before you go into a betting situation with like a poker game. Not that I play poker, but the aspect of it is I do understand betting. And if you were going to bet, and you don't want to go and tell everybody what your cards are beforehand, so there's just a lot of aspects that you have to take in all these considerations. But granted, you want to get an attorney that can think complex, but you're always at the mercy of the attorney because he knows the law and he's an officer of the court, and you know what your facts are. There's always a big dilemma with that.
one of the things I've noticed and always thought when I was watching things happen within a courtroom that I think a majority of people don't really, it doesn't really click in their head is that
Hmm.
these attorneys work primarily in the same courthouse all the time, arguing against the same other attorneys very often, and extremely often in front of the same judges or judicial administrators. So they have to me, it seems like they have to kind of walk a little bit of a tightrope because they want to keep these people on their good side, not necessarily for this case or kind of to please the court just in this case, but they know they're going to be in front of them again 3 or 4 days from now, and a week from now, and a month from now. This is their career, this is their daily task.
This is far
So
beyond a social relationship. This is they're officers of the court, and they're not going to deny that. They
yeah,
literally
so
work for the they literally work for the court. It's not something
yes,
that's like a big secret. That's all I'm saying.
yes.
It's not like, hey, dude, I work here and I work with this guy all the time. This is Bob. Man, me and him don't gonna agree or whatever. Nah, nothing like that. They're literally officers of the court. So it's a little bit different. Now they want to talk to the judge with respect, but they don't ever want to get sanctioned. They don't ever want to say something the judge doesn't want to hear. That right there is where you're going to find some of the problems with having an attorney. And I'm not saying that for like everybody's experience. I'm just saying that sometimes if you have a real hard issue and the judge and the attorney really has to do some hard work on that, and it's easier for him to just deal with the situation and move on instead of actually having to do all the damn hard work. He may not have the team to do it. He might not be capable. So he's not going to tell you that, but he'll definitely come to another conclusion that you don't like.
Well, Jeremy, what about the analogy, say, of you or the common man or woman at their job, and they've got different managers they deal with, upper management they deal with, people at all different levels, and to me, maybe that's a little more similar to what it's like with an attorney. You know what I mean?
Well, yeah, I guess it would be like this is the boss. And this is like you're going to go talk to the boss and you're two different employees working for the same company. So you're going to go talk to the boss and you're going to try to get the boss to agree with you. And that's the kind of situation you're an attorney. If I was to explain it in a different insurance agent, and as an insurance agent, when I was an insurance agent, there was a guy that was called the SGA. And that was a state general agent. And whenever he was in the room, you don't want to piss him off. He was a guy, you know. So it was always like he was always held in high regard. You always want to be on his good side. He had more control of everything that you could even imagine. He can make your job disappear. So there's always that.
Well, if anybody's been in the military, they'd be very familiar with the statement, "Officer on deck."
Mm-hmm. Very good point. Very good point. So yeah, there is that kind of conflict of interest whenever you are having any attorney that represents the bar association represent you. That is a conflict of interest. And the thing is, like in criminal cases, they can't really represent you based on the fact that they would be charged. They could be held for the same charge. So really, they're not there. They're only good for bail hearings.
I would say that's probably the reason why the majority of attorneys, I would say maybe close to 97, 98, 99% of them never argue cases, rarely ever argue cases. They're
Mm-mm.
always, you know, conning you in to plea deals and getting you to plea out, to maybe a little bit lesser offense. That's why they'll throw 4 or 5 offenses at somebody, knowing that, yeah, they're going to knock out like 3 of them, so you feel better about it, and they're still going to convict you of the one they really wanted to in the first place.
Right. Well, I've sat down with some attorneys quite a few different times, and they've always explained to me it's easier for me to just get a plea bargain and get paid by the court than to ever get paid by the people that I'm working with.
Yeah.
I've heard that from many different attorneys, all on the DL. You know what I mean? I was like, how in the hell could you guys do this? They're like, well, it's easier for me to just make deals with the court to get paid instead of because most of these people can't pay you.
And the majority of people don't have necessarily 20, 30, $50,000, to put down as a retainer for an attorney to argue a case. One of the things I've heard as well from them, that, this is kind of how crooked things can be, is that somebody
Hmm.
will come to them and say, "Oh, I've got this situation or whatever. I can give you $25,000." And it's a state case, and that attorney knows, he knows
Hmm.
in his head that within about a month or so, that case is going to become a federal case. And he tells them, "Here, yeah, at the state level, yeah, I can take care of this for you at the state level. I don't know if this will go federal or not, but as far as it's state, I can take care of it." And then boom, month and a half later, when it goes federal, they go to him and they're like, "What are you doing? What do you mean you can't?" He's like, "Hey, I told you, I can help you at the state level, not the federal. You're gonna have to go find another attorney now." And
Hmm.
they just picked up an extra, a quick 25, $30,000 there.
Yeah. It happens pretty quick like that. It's not really a there's a no mercies kind of thing going on with a lot of these guys. They're really good at. I don't want to insult people, but it seems like a lot of them are better at doing something besides winning. Like they don't really want to win your case; they just want to separate you from your money.
Yep. Uh, Maybe partially where
And
that word torn comes from.
well, you also got to understand that if you can call them on that, you can get them disbarred. But the aspect of calling them on it is you're going to have to prove it on evidence, and then you'll have to show it. And then you're going to have to get them to testify, and then you cross-examine them probably or whatever. But it's never an easy process, but it is a process, and you can do it.
Yeah. And now you're just opening up a whole new, brand new freaking situation when you still have that original situation to go through. So,
Oh yeah, but at the same time, if the situation is connected to them being dishonesty, you can get rid of a bad attorney at the same time. Just get your evidence argued correctly, because really you want to clean up the courts. You don't want to have a whole bunch of crooks in there running the courts. So it's better for the pro se litigants to get involved and understand what the rules are, so proper complaints can actually get filed. That would help out a lot because most of the guys in the club ain't gonna turn each other in.
and, and also, I want to identify a legal fallacy that gets passed around to a lot of people at the same time in a situation like this or any other. You do not want to put a lien on a judge or anybody like that. Stay away from
That
that crap.
that is probably one of the most far beyond logical things you could ever do. It's like I want to go argue with the judge, but I'm not gonna. Yeah, I mean, if you were in a basketball game and there was a referee, or no. If you're in a boxing match and you're in a referee, do you think putting a lien on the referee's house is going to help you win that case?
Right.
Oh hell no! That is a ridiculous argument. So I don't understand why people do that. Granted, they're like, "Hey, this is cool, whatever," but there's actually federal law that says that you can go to jail for 10 years for doing that. And I would never do anything like that. It's out of character and it's just completely disrespectful. And at the same time, it's highly frowned upon and it's actually a crime. So it's not something that you can do. I mean, granted, there were people in the day back in the day that they did all kinds of stuff because there was open procedures for certain things. However, a lot of that stuff is gone. However, people are like, "Oh, I'm still going to do it." Well, yeah, that never ends good, and I think it's just a bad idea in general to attack the referee. You have another situation. If you have a biased judge, you can prove that by using your evidence and stuff like that. And then you also have the appellate court. But you also got to understand it's not just the appellate court. You have the Supreme Court, then you have the federal court, then you have the district court, and then you have the Supreme Court above that. And man, those are different, completely different arenas with different judges, and it's a lot different than just having one person ruling your stuff. And it kind of gives you a little bit of understanding of how you're going to get up even farther. I don't know. It's a very interesting situation the way they created everything. It's all put in layers. You have like the lower court, what doing what they do, and then you have the higher court examining what the lower court does. And sometimes you'll get into situations where the higher court doesn't want to get involved, so they'll just deny your stuff because they don't want to get involved. And then you get beyond that, you go to a higher court than that, and they don't want to even get involved. And then you got to go above that, and then they may not want to get involved, but at the same time, most of the time, once it goes federal, they don't have control over it anymore. So that's why it's always a big deal. But if you can go there, it's got to be a strong argument.
Well, it can be a long battle, and justice is expensive too. So it all kind of depends on how much justice you can afford.
Well,
You mentioned,
as Joey said, um, justice is expensive, so it was more beneficial to us to learn how to do the law ourselves, so we didn't have to pay 1,000 attorneys to follow us around all the time.
absolutely, and that's part of the purpose of this group as well. And but yeah, I mean, and you mentioned federal statements of doing up to 10 years, cases of doing liens. But, Jeremy, you and I know people in Colorado doing as much as 30 years right now for that same situation.
I think that guy, if I don't know all of or whoever did all that, I've heard of them, but I think I did talk to one guy, and he was all talking like, I mean, he went turbo. I know there's people out there that are actually like logical in their position, but then when you start impersonating certain people and officers, that is absolutely absurd. Well, anyway, he had done this and met him, and then he was talking about doing that stuff. And boy, did they throw the whole book at him and the kitchen sink too. And I think they might have thrown the hot water heater at him. It was horrible, bro. I mean, they smashed him.
Yeah,
So
and making office claims like that to me is crazy. I know plenty of people that claim, like to be a postmaster general or whatever, people that can't even probably afford to buy a book of stamps. So,
right, and they're going extra. I mean, some people they've got all these magnifying titles, which gets interesting. I guess it's for entertainment value, but they all have like this ego thing.
well, Jeremy, thanks for being here. I think this is just a quick little short synopsis of things that people really don't stop and think about or hear uh, when they get into trouble or prior to it even happening. And so they walk in totally blind. And that's what we're trying to avoid here.
Absolutely, I would say last thought would be try to keep it as professional as possible. Don't ever act like a fool because they will treat you like one and they will oblige you. And just make sure to be a professional. And if you're professional, anywhere you go, it's always going to benefit you, but especially in the court.
And also there's a statement that you've made before that I think everybody should like have tattooed on their brain, and that is that out of the facts arise the case.
Yep.
And so that's what you want to look at.
Well,
If
the maxim, let me say it properly. Out of the facts arises the issue. If there is no facts, there is no issue.
Absolutely. Perfect way to end it with tonight. Thanks, Jeremy. You have a good week, brother.
Be blessed. You too.